All right, we'll go ahead and get started. I do appreciate you guys being understanding. Yeah, had a sick kid this morning, had to go to the doctor and all of that, and just would prefer to stay home so I can be close in case I need it. Also, running on about 3 hours of sleep, so a little bit punchy. Do apologize about that as well. I have absolutely had it Canvas's um, with Canvas's studio system. It's not good. I don't like it. I don't think it's intuitive. And I'm not some, old tech illiterate individual. So what we're going to do is this. I am going to create essentially a private YouTube stream that is not public and can't be shared. And I'm going to post that. I'm going to post all the videos there. I'm going to do them once a week, and that's what I'm going to try and do. So you guys, for those of you who can't make it, you can. I do hope that you continue to come to class and all of that, but that's how it's going to be for the recorded lectures for the foreseeable future, including this one. Today, what we're going to do is really focus on unprotected speech. We talked the last class a little bit about how the United States has a long and storied history of protecting things like hate speech, and that's a category of speech that other countries have decided is not worthy of any sort of protection. And so that is a difference that we have. But one of the common misconceptions that I see is this idea that all speech is protected and all categories of speech are protected under the First Amendment. We have this sort of absolute freedom of speech in the United States. And the fact of the matter is that that's not correct either. The people who say hate speech isn't free speech are just as wrong as the people who say I have an absolute right to free speech. And we're going to start with kind of going through these categories. And it's really important that as we move forward, you understand that these are categories of speech that the Supreme Court or other courts have said, look, this is just not incorporated as part of the First Amendment, right? When the people wrote the First Amendment in 1791, that it just was not intended to be included. It was supposed to be outside the purview of what we consider protected speech. And one of the first example of that we often see is something called fighting words. And I'm going to run through these pretty quickly because you're hopefully not going to see them too much in your everyday life, but it is a good illustration of how the Supreme Court can just say, yeah, that's speech, we're not going to protect it. It's from a case called Chaplinsky versus New Hampshire. And the statute at issue, and remember, whenever you are arrested and charged with something, you can't be arrested and charged with something just because the cop doesn't like it, or because the judge thinks that you did something wrong, or even a jury of 12 of your peers just don't like you as a person. There needs to be an actual law that you have broken. And so in this case, the law that was allegedly broken was a law that prevented the use of any offensive, derisive, or annoying, that's my favorite one, word to anyone who is lawfully in any street or public place, or to call him by an offensive or derisive name. Now, at its surface, this is obviously going to be an unconstitutional statute, okay? It is a law that prevents people from speaking. It is a very vague statute, right? It doesn't really put people on notice as to what they can and cannot say. It doesn't, it would theoretically incorporate a lot of political speech. And as we've seen in cases like Texas versus Johnson or United States versus O'Brien, even speech that is offensive or what would be considered problematic or whatever adjective you want to assign to it, those are protected elements, even if the vast majority of society finds them abhorrent. And that's actually the point of the First Amendment. If we only protected speech that we liked, then we wouldn't need it. Nobody's going to pass a law saying, posting a picture of your cute cat is illegal. So we don't need constitutional protection as a bulwark against the will of the majority, to the oppression of the minority. And by minority, I mean minority opinion in this particular situation. But anyway, and so that's the statute that New Hampshire passed. And what happened is Chaplinsky was a socialist political activist, which is protected, right? You can't go to jail for being a socialist. You can't go to jail for being a communist. You can't even go to jail in the United States for being a Nazi or a white supremacist or a member of a terrorist group. Now, you can be arrested for a conspiracy. That's a separate issue, but simple political affiliation is protected. But what Chaplinsky did is he went up to a police officer and he said, "You're a damn racketeer and you're a damn fascist." And the cop arrested him, and arrested him under this statute that made it illegal, made it essentially a breach of the peace to utter these words. And the court was looking at, does the First Amendment protect speech that is likely to result in violence or public disturbance? And that was New Hampshire's argument here. And the Supreme Court said, no, this speech is not protected. And if the speech is not protected, then the government is given wide range to try and overturn it, or sorry, not to police it and to cull it through criminal enforcement. So the rationale was not that this passed strict scrutiny. It obviously didn't. It's far too vague to pass strict scrutiny. It's far too ripe for abuse to silence dissenting opinions. And so, like, how in the world did the Supreme Court get around this? And what they determined was, and this is a quote from the decision, that there are certain and well-defined and narrowly limited classes of speech, so classifications of types of speech, the prevention and punishment of which have never thought to raise constitutional problems. And this is what we call a historical and originalist argument. And this is a really important thing, not only for how we're going to look at this class, but also how the Supreme Court and how constitutional protections have been interpreted over the past 240 years, 230 years. There are two schools of thought when it comes to how should one interpret these, by and large, incredibly vague constitutional edicts. We already talked about how if you take an incredibly literal viewpoint about what the First Amendment protects, it allows pretty much any state government to say, we're going to arrest you for saying a word we don't like, or we're going to throw you in jail for not being a Quaker. Perfectly fine, because it only limits Congress and it only limits speech, not conduct, not expression, not even writings, only speech. Additionally, you have something like the 14th Amendment, which looks at the equal protection. Well, equal protection for who? Should it only be equal protection for people of different races? Should we have to equally protect people of different political affiliations? Should we look at gender? Should we look at gender identity? Should we look at national origin or religion or hair color, right? Equal protection is an incredibly vague term that is open to interpretation. So courts are oftentimes tasked with determining what does this mean. And two schools of thought have kind of come to the fore in the past 30, not even 30, more like 40 to 50 years or so. On the one side, there's something called originalism or textualism. They're oftentimes confused, but they are close enough where I'm going to talk about them in the same breath, even though there are some differences between the two. A historic or originalist argument says that we should look at these constitutional protections, these statutes, in terms of what the writers meant at the time. So when we're looking at the First Amendment, what did the people who wrote the First Amendment and adopted the First Amendment mean by speech or religion or press or petition? If we're looking at the Equal Protection Clause, we're looking at what the people in 1860 something, I think 65, meant when they passed the 14th Amendment. Did they mean people, how did they define equal protection? And that's why we get equal protection primarily covering race, because we just fought a war about the equality of races and the moral imperative that comes from not enslaving somebody based on the color of their skin. So we fought a war over racism. We didn't fight a war over gender. We didn't fight a war over age. We didn't fight a war over hair color. And so that's why the 14th Amendment doesn't protect everybody, but really focuses on race and national identity and religion. So, and this is not to say, and I'm not advocating for a textualist argument, but oftentimes this is criticized by saying, well, it shows like a deification of the founding fathers or the people in the 1860s. And that's not really what it is. It's more like the Constitution is not good or bad. The Constitution is a framework for the government. And so we should look at that framework as the people who wrote it intended. And if you don't like that framework, then you can always feel free to amend that Constitution. That's one side. On the other side, you have something called a living document, or a living constitution, as it's sometimes called. Living constitutionalists will say that the Constitution was never intended to be static. It was never intended to be set in stone, that even the people who wrote the Constitution did not intend for their views to be paramount. Instead, it was supposed to lay out a series of rules, a series of policy statements that will evolve with the times. So we are instructed to look at what speech means in a modern context rather than a historical context. The criticism of this approach is that it allows individual judges to substitute their own judgment for democratic will, and that oftentimes leads to the subversion of democratic will, because it allows the judges to be super legislature in and of themselves and can't be reviewed by outside bodies. So that's I know that's kind of a little bit of a tangent, but it is important to know how we look at these things. And the court in Chaplinsky, to bring it back to what we're talking about, they used a historical and textualist argument. They said, look, when the founding fathers, when James Madison went off to his little lunchtime retreat and wrote the Bill of Rights in about 40 minutes, when he did that, the states, when they adopted it, they never intended for this to be included. And therefore, the state is free to punish Chaplinsky, and therefore did. They arrested him, they charged him with disorderly conduct, and he was convicted. Okay, so that is kind of the starting point here. Fighting words that are, because I got to go back, words that are, their very utterance tend to incite an immediate breach of the peace. And here is really where the court tries to walk a very fine line. And that fine line is that they are not saying we are punishing Chaplinsky based on the opinion we disagree with. What we are punishing him for is that when you utter these words, especially to somebody, that it is likely to lead to violence. And a government should be allowed to cut off the sources of violence, sources of civil unrest, prior to them actually being fermented. So to use the, powder keg and match analogy, right? You have this powder keg and all it's going to take is a spark in order to ignite. It allows the government to take out the powder keg and stop the kind of the elements needed for violence to occur. And then in 1970, the court ruled on a case called Cohen versus California. And in that case, the defendant, who is Cohen, wore a jacket with the letters "fuck the draft" emblazoned on the back. And he went to LA County Courthouse because I think he was there for jury duty, actually. And he was asked to take the jacket off. He refused, and he was arrested. He was arrested for under a statute that made it a criminal offense to, I like this one, maliciously and willfully disturb the peace by offensive conduct. Now, obviously, that is going to be incredibly broad because what people find offensive is going to be dependent on the individual, and it does not put a potential infringer on notice as to what they are or are not allowed to say. but he was arrested and sentenced to 30 days in jail. Now, if we look at these two cases, right, we look at Chaplinsky and we look at Cohen, on their face, they are relatively similar. Both of them involve using foul language. Actually, you can make a strong argument that Cohen's saying fuck and Chaplinsky saying damn. Cohen said something certainly more offensive. Both are likely to result in disturbances of the peace, right? Especially when you give an opinion on a political matter in an offensive or hyper-partisan, maybe not hyper-partisan, but a hyper-inflammatory way, you have the risk of having violence. And the statutes that they were convicted of are equally vague, right? They prohibit offensive conduct or disturbing the peace, right? There's not a lot of notice given to the individuals. But in Cohen, the court said that was not fighting words, that speech was protected, and the conviction of Cohen under the statute was unconstitutional. Now, I'm curious, but what they did say is that the court went out of its way to say, look, we are not overruling Chaplinsky. We still believe that fighting words are not constitutionally protected and can be prohibited pretty much in whole cloth by the government. Now, this is a very technical issue, but I'm curious if anybody knows, what is the main difference between what happened with Chaplinsky, where he went up to the police officer and insulted him, and what happened in Cohen? What's the difference between those two individuals and how they express their opinion?
One was verbal.
Kendall, yeah, one is verbal. That's certainly good. That's close to what I'm going for. Anybody have any other ideas?
Is Chaplinsky covered under the First Amendment because freedom of expression?
Chaplinsky is not. So Chaplinsky was arrested, thrown in jail. Tough.
I meant Cohen. The one who's wearing the jacket. Cohen.
Yeah, Cohen guy wearing a jacket got off. Chaplinsky got arrested.
I don't know. That was my answer. I was saying because it's protected under the First Amendment. But.
So you're right that because it is absolutely protected under the First Amendment. So the conclusion is right. The reason why is a little bit technical and not immediately apparent, but it is really important. Cohen actively engaged the police officer, went up to the police officer and said, "You are a damn fascist. You are a damn racketeer." So Cohen was the one instigating the potential for the breach of the peace. And it is, while not allowed, it is certainly understandable that if somebody comes up to me and uses charged language, especially if it is some sort of slur or thing like that, then there's understanding that you might get punched because it's kind of a snap judgment, heat of the moment thing. Cohen was passive. He wore a jacket. He didn't go up to anybody and try and engage with them. He sat in his jury box and he wore that jacket. If somebody is going to breach the peace, they have to take the affirmative step of going over and engaging Cohen. That's the main difference. Is fighting words, really fighting words have to be initiated, right? So the individual who's getting arrested has to be the instigator in starting that conflict. And that's going to be the main difference. So fighting words is very unlikely that you can be found guilty under a law that is constitutional by doing something passive, such as wearing clothing. And that'll be pretty important when we get to things that are allowed in school a little bit later on in the semester. And that's pretty much the two fighting words cases, right? Chaplinsky was the 1930s, Cohen was the 1970s. That's it, right? The court has pretty much went 40 years between cases saying, these are your guideposts, right? This is what we think. Really, that's not a great deal of specification. So we then have a case in 2010 called Phelps versus Snyder, and we're going to watch that a little bit, and then we're going to talk about why the outcome was what it was.
5 years ago today, Marine Lance Corporal Matthew Snyder was killed while serving in Iraq. Yesterday, the Supreme Court said protesters who showed up at his funeral were protected by the First Amendment. And now the Westboro Baptist Church says they want to quadruple the number of protests they hold. CBS News Chief Legal Correspondent Jan Crawford is in Washington with more on this story. Jan, good morning.
Good morning, Jeff. You know, this is a heart-wrenching case. I mean, these protests come at these families when they're at their most vulnerable, when they're grieving the loss of their loved ones. God hates America. The message from the Westboro Baptist Church is hateful and offensive. Church members believe God is killing all American soldiers because the country tolerates homosexuals.
We are trying to warn you to flee the wrath of God, flee eternal destruction.
The church has protested at more than 600 funerals of U.S. soldiers, like Matthew Snyder, who was killed in Iraq. Matthew's father says the protests stole his last moments with his son. He sued the church for emotional distress and got a $5 million judgment. But the Supreme Court said in an 8-1 decision that the church doesn't owe Snyder a dime. The church protests on a public sidewalk and on a matter of public concern were protected by the First Amendment. In an interview with CBS Evening News anchor Katie Couric, Snyder said if courts won't intervene, others will.
And believe me, someone's going to get hurt. And when the blood starts flowing, let it be on the Supreme Court justice's hands.
Now, only one justice dissented. Justice Samuel Alito said these protests were just verbal assaults. They didn't add anything to the public debate, and so therefore they could be banned. You know, all they do, he said, is hurt these families who simply are trying to bury their loved ones. Jeff?
They certainly do that. All right, Jan.
Sorry about the weird frame rate on that one. So, obviously, that is, from a personal standpoint, kind of tough to watch. You know, in terms of sympathetic plaintiffs, sympathetic defendants, you have the father of a soldier killed in action, and then you have somebody who is thanking God for his death, right? In terms of personal sympathy, we're all pretty much on the same page as to which way it goes. However, in Phelps versus Snyder, the court determined, and this is okay, so first off, we have to be able to establish, we need to walk through how Snyder was able to get this judgment in the first place, right? Because a court can't just say, hey, how do you like $5 million because we like you and we really hate these Westboro Baptist Church people. There needs to be an actual statute. And essentially, it was intentional infliction of emotional distress. When you intentionally go out of your way to cause somebody emotional harm, you can be compensated much in the same way as a physical harm. Get punched in the face, you can sue them, you get money. Somebody cause you emotional distress, you can do the same thing. The Westboro Baptist Church sued, saying, look, by forcing us to pay money to this individual, you are punishing us for constitutionally protected speech. And the state and state's response and Snyder's response was, well, these are fighting words, right? Can you think of a more emotionally charged situation than a grieving father who is forced to confront individuals who think that his son deserved to die because of America's tolerance of homosexuals? And that is, as far as likely to breach the peace, pretty darn far up there. I can't think of anything that would make me more angry and more willing to commit violence, and I imagine that you are similar. But the court said no. Look, they're in a public place, right? They're not going into somebody's backyard. They're not like actively going up to somebody's face like Chaplinsky did, like right up next to them. They are in a place they are constitutionally allowed to be, and they are talking about a matter of public concern. They are talking about, and that really illustrates to me how broad the Supreme Court, and this is pretty uniform over its history, defines public concern. They are not in a position to say your religious belief that these soldiers are dying because of a vengeful God is dumb, is immoral, is incorrect, because the government is almost never going to be able to tell somebody that their religious belief is wrong, their political belief is wrong. That goes against this kind of fabled marketplace of ideas, and it really messes with the idea of separation of church and state. And so that is, it is going to be a matter of public concern, right? These religious beliefs, these political beliefs, and punishing somebody for expressing those political beliefs and is going to be an anathema, or kind of goes against everything we believe the First Amendment to be. And what's really important, and the last thing I'll say about this case is, this is not a close decision. It's just not, right? It is 8-1. So for those of you who are familiar with the makeup of the court, like, you had some of the most conservative justices in history. You had Antonin Scalia, maybe not history, but in terms of the modern day definition of conservatism, legal conservatism, you had Antonin Scalia, you had Clarence Thomas, then you also had Ruth Bader Ginsburg, and you had Sonia Sotomayor. Like, all of these people were on the same side of this. So this is not a left versus right thing. It was just in line with an incredibly strong protection of First Amendment and free speech rights. And that is why fighting words, while not protected, are going to be incredibly difficult to prosecute, and why we're only spending about 20 minutes on them, because you're not going to see them very often, and is really going to come more within the purview of incitement than their own thing. But speaking of incitement, I'm curious, did anybody get a chance, I hope you did anybody get a chance to read the actual articles of impeachment against former President Trump? That trial is supposed to start next week. In order to be impeached, you need to be convicted of what's called a high crime or misdemeanor, right? You can't just, you can't be impeached allegedly because Congress doesn't like the president. There needs to be an actual reason. There needs to be some sort of offense against the United States. What was the offense that Congress charged former President Trump with committing when they decided to impeach him? Does anybody remember?
Wasn't it treason?
It wasn't quite treason.
Wasn't it inciting violence?
It was. So it was inciting violence. Now, Jalen, you bring up a good point, and we'll talk about it. And I'll talk about the impeachment trial kind of as it proceeds. There is a move from, and this is from Senator Susan Collins of Maine and Tim Kaine of Virginia, to essentially make a determination that allows Congress to make a determination that President Trump engaged in treason and insurrection against the United States. And under the 13th Amendment, that does allow them to prohibit him from ever holding future office, which would be interesting, because that's really what the goal of the impeachment trial is. Because normally you impeach somebody to remove them from office. Donald Trump has been in office for 2 weeks now. So that's not going to do it. It's really going to be about inflicting the punishment of not being able to run for president again in 2024 or 2028. So Jalen, that you're correct that can be done, but it's not what the actual impeachment trial, the impeachment was. The impeachment was insurrection, or not. It was for incitement. It was incitement of violence against the incitement of the insurrectionist crowd. So while Donald Trump wasn't insurrectionist, he incited the insurrectionist mob that stormed the Capitol. Now, we'll look at whether or not, what Congress means, or what the House of Representatives means when they actually talk about insurrection, and how it might be different than maybe the legal definition we'll talk about here now. But let's start with the actual definition. So the definition is: incitement is speech that is done with the intent of persuading others to commit unlawful acts. Now, again, incitement, just like fighting words, are a classification of speech, classification of expression that is not protected by the First Amendment. So if you can convince a court that the words you are trying to prosecute, that the speaker who spoke the words that you're trying to prosecute meets within the confines of incitement, you do not need to meet strict scrutiny. You do not need to show anything other than that they met those words, and that, you know, the government then has the ability to does have the ability to prosecute, arrest, and imprison them. But incitement is going to be a very narrow exception, especially in the aftermath of January 6th. The word incitement was thrown around a fair amount. And I'm not here to tell you that those were, you know, that's necessarily wrong. More that I want to, there's going to be a difference between colloquial and everyday use of the word incitement and actual legal, not protected by the First Amendment incitement. Okay, so Brandenburg versus Ohio, the case I had you read. And I'm of the opinion that I want you guys to just read the, like, a lot of times the Wikipedia summary of these cases is good enough for me, you know, because you know, I might have you, and I will have you guys read some case summaries, like actual cases put out by the Supreme Court. I tend to find that that's not incredibly helpful because you don't know how to read those. You don't know how to read the decisions, and they're not, and there's no reason for you to. So a lot of time we're just going to be looking at the Wikipedia entry, and that's good enough for me. But in Brandenburg, and I'm going to, you know, kind of give you some context here. Brandenburg was the leader of an Ohio chapter of the Ku Klux Klan. And in 1967, I believe, he gave a speech in his little backwoods KKK chapter. And he promised, among other things, revengeance against the racial slur and Jews and those who supported them. And he called on the KKK to march on Washington. And here's the quote that I find kind of funny, actually. Not funny, haha, but just interesting. And quote, "While we are not a revengeant organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some sort of revengeance taken." First off, revengeance, not a word. Not super surprised that the leader of the Ohio chapter of the KKK, not super literate, but it's not a word. So it's kind of difficult to know what the heck he's talking about. But we can assume that revengeance means some sort of violence, right? Because he says we're not violent, but if we need to become violent because you won't uphold white supremacy, well, then that's not our fault. You gave us no choice by giving, you know, people of different races and non-Christians rights. I mean, what do you expect us to do? You can't expect us to stay peaceful in a situation like that. So that's what he announced. And the Ohio State Police arrested him, they convicted him, and they convicted him under a statute that criminalized incitement, okay? And their argument was that, look at the legal definition, right? That the legal definition, that he was attempting to persuade others to commit unlawful act. The unlawful act is literally march on Washington and trying to overthrow the government via violent means. Now, what the heck does that sound like, right? So this is kind of how we define incitement, right? You are not criminalizing the speech. You're not criminalizing the opinion that you find distasteful. What you're criminalizing is the advocacy for illegal acts. And by cutting off that advocacy, you lessen the risk of actual legal acts being committed. At least that's the theory behind incitement laws. But the conviction was overturned. The conviction was overturned because the Supreme Court determined that it did not meet the legal definition of incitement. And this is going to be really important both for exam purposes, but also as I do hope that you watch or follow the impeachment trial at least a little bit, because it's only happened 4 times in our history. Now, twice in a year, but 4 times in our history total. And so this is kind of and I don't mean to get all soapboxy, but, you know, this is an important moment, right? This is something that we just don't see very often and is relatively historic. But when you see these arguments about incitement, And former President Trump's lawyers have already gone out and made the argument that the Supreme Court made in Brandenburg versus Ohio. Sorry. Which is that while this might be distasteful, this might be problematic, this might be really offensive speech, it does not reach the level of incitement. In order to reach the level of incitement, you need to show two things. Number one, the advocacy is directed at inciting or producing imminent lawless action, and the speech is likely to produce such action. Now, both elements must be present in a case. It's not enough to just show that the intent was there. It's not enough to show that it was likely to produce such action. You need the subjective intent on behalf of the speaker, and you need the objective or reasonable standard that is likely to occur. So let's give an example. And this example is from 2012, I believe. I believe it's 2012. Ferguson, Missouri protest. I believe this is the Michael Brown case. And after it was, a grand jury decided not to indict the police officer who shot and killed Michael Brown, there was a lot of protests, and not often, but in certain situations, those protests turned violent, especially in Ferguson, where we saw things like looting, we saw things like fires being set, the classic definition of what you would consider to be a riot. And there was video of Michael Brown's mother and I believe it was stepfather or either the boyfriend of his mother. I don't remember if they were married, but there was a relationship between him and Michael Brown after they got the news and were speaking to a crowd. So we're going to watch that and then look at whether or not we can make an argument for or against finding that this might be considered incitement to violence.
They think this a joke.
They killed her baby, man.
They want him back in Ferguson. I can't get nobody back.
You can't get nobody back.
They still don't care.
They don't care.
They ain't never gonna care.
Because it ain't their kids.
I've been here my whole life. I ain't never had to go through nothing like this. We gonna get justice. We gonna get justice.
Leslie McSpadden's immediate reaction, which was caught on videotape after hearing the devastating news that the killer of her child was not going to be brought to justice, was overwhelming to her. She, as a Ferguson community, understands that we all have a responsibility to protect the community. Nobody is going to condone violence, and we're going to reject it. And as Reverend Al said, people who do that stuff, it's not appropriate. Michael said it so eloquently, asking for peace and calm. And so we'll move on.
Okay, so I know that it was censored, but what the guy was saying, what was caught on video is him saying, "Let's burn this bitch down." Now, that was caught on videotape and was blamed, maybe in bad faith, on why the protests in Ferguson, turned violent in certain instances. So let's look at sort of a mechanical legal analysis standpoint. And one of the kind of tougher parts of doing law, and one of the tougher parts of, thinking through these things in a way that we kind of have to, is removing emotion from it a little bit. But that's kind of, in order to study the law, it's kind of what you need to do in a lot of cases. But let's kind of look at it, right? Does is the advocacy directed or inciting, or directed at inciting or producing imminent lawless action. The lawless action would be the actual destruction of property, violence, whatever you want to call it. Is it imminent? The answer is yes, it is. This was done in a crowd in Ferguson, Missouri. He said, burn this bit down. There were fires set, right? They were set immediately. They were set while in the approximate vicinity of the words being spoken. Number two, was it likely to produce that imminent lawless action? Here's where you get into a little bit, it's a little bit tricky. Because obviously lawless action had happened, okay? There was illegal conduct that occurred on that night. Was that as a direct result of what Michael Brown's stepfather said? Or was that going to happen anyway? And that is going to be a very difficult line to draw. So you can make an argument for or against the likelihood that it would be, that the likelihood that the lawless action would occur, but it's not always necessarily clear. Now in Brandenburg versus Ohio, the issue you run in, and just so you know, as far as I know, Michael Brown's stepfather was not charged. As far as I know, he was not convicted under incitement. So this is purely a hypothetical, but kind of illustrates maybe one of the differences between this case and Brandenburg. Now, Brandenburg, again, the Supreme Court is not saying we're overturning this conviction because we like white supremacists, that we, the Supreme Court of the United States, absolutely love the Ku Klux Klan and we want them to be able to do whatever the heck they want to do. No, that's not what they're saying. What they are saying is, you know, whether you agree with them or not, but what they're saying is that this is not imminent. What Brandenburg does when he makes his speech is he does a couple of things. Number one, he says, in the future, we have to march on Washington. Number two, he qualifies it. He's not saying, well, goodness, guys, we're absolutely going to overthrow the government. He's like, well, maybe we might have to, maybe we won't. I'm not entirely sure. And number three, Ohio is nowhere near Washington. So the difference between what, you know, the clip I just showed and the case in Brandenburg is, in order to actually have lawless action occur, all Brandenburg and all of his little racist friends would need to load up into cars, drive all the way to DC, and then be violent. And incitement really is designed to prevent this kind of mob mentality. There's a really good book for anybody who's interested in this sort of thing. It's a book called Among the Thugs, and it's by a guy named Bill Buford. And it's about his time really living and following English soccer hooligans in the 1980s and early 1990s. And, you know, soccer hooliganism has kind of had this funny little thing, like it's on The Simpsons. Eurotrip has a funny little thing about Manchester United, but like there was a period where Manchester United fans went to Turin, Italy, where a soccer team called Juventus is. And Manchester United fans would prowl the streets, and if they found somebody wearing a Juventus shirt, they would literally kill them. They would literally track them down and stab them until they were dead. And dozens of people died this way. And the reason I bring that up is because Buford, when he is describing it, is describing this sort of collective consciousness of the mob, collective consciousness of the riot, that you give rational thought over to this outpouring of really extreme emotion. And this is something that we have seen throughout history. Mob mentality riots are not a new thing. And so incitement, from kind of a sociological perspective, is intended to prevent, again, the lighter and the powder keg and the lighter analogy. With incitement, you eliminate the spark. You eliminate the ability for that unrest, that, you know, anger that is bottled up inside to be ignited, and that's how you prevent violence. It's how you prevent unlawful activity. So the question becomes, is this incitement? And we'll see if this works.
We have hundreds of thousands of people here, and I just want them to be recognized by the fake news media. Turn your cameras, please, and show what's really happening out here. Because these people are not going to take it any longer. They're not going to take it any longer. All of us here today do not want to see our election victory stolen by emboldened radical left Democrats, which is what they're doing, and stolen by the fake news media. That's what they've done and what they're doing. We will never give up. We will never concede. It doesn't happen. You don't concede when there's theft. Our country has had enough. We will not take it anymore. And that's what this is all about.
Okay.
And to use a favorite term that all of you people really came up with, we will stop the steal. Today I will lay out just some of the evidence proving that we won this election, and we won it by a landslide. This is not a close election. You know, I say sometimes jokingly, there's no joke about it. I've been in two elections. I won them both, and the second one I won much bigger than the first. Okay. And by the way, does anybody believe that Joe had 80 million votes? Does anybody believe that? He had 80 million computer votes. It's a disgrace. There's never been anything like that. You can take third world countries. Just take a look. Take third world countries. Their elections are more honest than what we've been going through in this country. It's a disgrace. It's a disgrace. Even when you look at last night, they're all running around like chickens with their heads cut off with boxes, and nobody knows what the hell is going on. There's never been anything like this. We will not let them silence your voices. We're not going to let it happen.
Okay, so that's just kind of a clip of former President Trump's speech on January 6th. It was part of the Stop the Steal rally. He, on Twitter, when he used to have a Twitter, invited people to come to Washington. He told them, be there, be rowdy, and then, said that I want you, everybody, turn around. After this, I want you to march on the Capitol, and I want you to peacefully protest. I want you to make your voices heard. I want you to make sure that they can hear you in Congress as they work to certify the vote. He also said at various other points that you don't concede, that you fight like hell, that you never give up, right? The pretty inflammatory and pretty incendiary language. Now, what we're going to do now is watch about 50 seconds. Some of it's pretty disturbing. I'm going to go and let you know that now, but I think it's important, at least from my perspective, I do think it is important to lay out what happens with, what incitement is trying to protect against, and whether or not you think President Trump actually committed incitement, or this speech rises to that level, or whether or not you think that he should be impeached for it. That's neither here nor there. The reality is that what happened at the Capitol on January 6th is precisely the type of violence that incitement criminalization is intended to protect against. So we're going to watch a clip. It's again it's somewhat disturbing, but nothing, I've certainly seen worse as part of what happened at the Capitol. So. All right, so again, the reason I show you that is 5 people died at the Capitol. Somebody died because they were shot, right? The New York Times released body cam footage that showed the aftermath of a woman getting trampled because of the storming of the Capitol, right? Like, these are real consequences that happen. Now, the question becomes, from a legal perspective, did what President Trump say rise to the level of incitement? And let's look at why this case, we already looked at why what happened in Ferguson might, and I stress might, be different than what happened in Brandenburg. Let's also look at why what happened in DC on the 6th might be different than what happened in Brandenburg. And the main difference is the imminency requirement. When President Trump said, turn around, go march on the Capitol, it's right there, and fight like hell for your democracy. This is way different than saying Brandenburg in the backwoods of Ohio saying in a few months we're all going to get together in our cars and drive down there together. There's definitely an imminence requirement there. Whether or not is imminent enough, I don't know, because we haven't had a ton of incitement cases. The thing that I think makes it less likely that this would be considered incitement is that the advocacy wasn't direct. Former President Trump, so used to saying that, was oftentimes would kind of not give straightforward answers. I think that that's fair to say. And he's saying, look, fight like hell, but, be peaceful about it, but fight like hell, And when he released a statement on Twitter during the actual occupation of the Capitol, he was saying, be peaceful, but he never told him to go home, right? So there's always this kind of wishy-washy, am I advocating for it? Am I not advocating for it? And I think that what the real question would come down to is, with what Trump said, is it advocacy? Is it advocacy for illegal acts? I don't know. I think it's a close question. Now, we turn to what's going to happen with the impeachment. Impeachment is not a criminal action, at least not in the traditional sense, right? Nobody's going to go down to Florida and arrest President Trump, and they're not going to put him in jail for a little bit while they decide what they're going to do. If he does get convicted of impeachment, he doesn't go to jail. Worst thing that happens to him is that he loses his pension and loses the ability to run for president or any federal office again. But it is somewhat similar to, it's similar, but really not, it's not a criminal enforcement. So therefore, you don't have the same constitutional issues. Bottom line is this. The Supreme Court has repeatedly said, even in impeachment cases, that what is a high crime and misdemeanor, what is an impeachable offense, how a Senate runs a impeachment trial, those are going to be known as something called a political question. And the political question doctrine really holds that in order to, when Congress is doing something that Congress is, gifted to do, right? Run an impeachment trial, that the Supreme Court's just going to let Congress make that decision, right? So if Congress wants to say that incitement, but incitement that doesn't meet the constitutional requirement of incitement, and maybe some sort of less standard. If Congress wants to decide that's incitement, then Congress can decide that's incitement. That's perfectly okay. And so they're going to leave it to Congress. So it's very unlikely that President Trump is going to be impeached or convicted of impeachment. And if he is, sorry, I have a cat trying to get out. And if he is convicted, it is very unlikely that an appeal to the Supreme Court would be successful. Okay, and that's just something to keep in mind as we move forward. All right, now what we're going to do is, again, because I'm trying to move through these categories of speech relatively quickly. I used to spend more time on them, but again, My hope is that your work as a journalist, your work as a filmmaker, whatever, is not going to be inciting people to commit violence. I don't consider that a particularly good business strategy. What I can tell you, though, is that, especially if you're covering protests, that is something that I want you guys to be familiar with. And also just how strict, how narrow these exceptions are, right? So when the Supreme Court says incitement or fighting words is not protected by the First Amendment, what exactly they mean by that. All right. So far today, we have talked about the Westboro Baptist Church. We have talked about riots. We have talked about storming of the Capitol. And we've talked about the KKK. Well, unfortunately, again, we're not dealing with, particularly popular individuals all the time when we're talking about these things. So now we're going to move on to true threats. And we're going to focus on cross burning specifically to start. And again, no, it's not a fun topic, but when we're dealing with threats, especially threats that want to be criminalized, we're going to be looking at the KKK, we're going to be looking at white supremacists, we're going to be looking at, those are the heavy hitters, unfortunately, especially during the 1960s and the 1970s. So what we're going to do is we're going to watch a clip from Mississippi Burning, which I imagine some of you guys have watched when I was in college. My cats are fighting. I don't know why. When I was in college, we watched as part of Professor Barr's Movies That Matter class. It's really good. I really do encourage you to see it if you haven't. But it's about two FBI agents who go down to Mississippi to investigate the killing of, I believe it was 4 Jewish students at the time. I think. Maybe I'm wrong. Again, it's been like 12 years since I've seen it. But obviously, in Mississippi during the 1960s and the 70s, the KKK was an incredibly powerful force and would oftentimes lynch African Americans. And for those who they didn't lynch, they would burn crosses in front of as an act of fear and terrorism. Right, it's the same as it's similar to painting a swastika on a synagogue, right? It sends a message, and unfortunately, especially in that context, it sends a very, very specific message. So let's watch a clip of it, kind of give you some context as to cross-burning, and then we'll talk about how various attempts to criminalize cross-burning have been either successful or unsuccessful.
He looked at me and he said, "If you ain't any better than a nigger, son, who are you better than?"
You think that's an excuse?
No, it's not an excuse. This is a story about my daddy.
Where's that leave you?
An old man who was just so full of hate that he didn't know that being poor was what was killing him.
Get the light! Get the light!
You all right? I guess he knew we're here.
Now you know what you're getting into.
I'm gonna call Washington. I need more agents.
Would it make any difference if I told you that's exactly the wrong thing to do?
No.
Okay, so I also find that clip because I'm not entirely sure that 80 synthesizers is super appropriate. Thank you, Cats. Yeah, I mean, this is tough. This is tough material to get through. And one of the things that I do want to kind of start with before we even get into this conversation, and it's something that we'll see next class, is that these cases, I think it is a little bit dangerous to talk about them in a sort of academic setting, right? Or because it sterilizes it in a little bit, in a way that it's important to think about the real people behind this. I don't know. I don't really know what I'm trying to say, but yeah, it's not easy. And having that, and I'm going to try my best to think about the actual context that these are actual real people that are involved with this. But anyway, we all understand that cross burning is expression, right? We look at the test for, is it expression? Now, burning a cross is conduct, but there's an intent to convey a message, and we are darn sure that everybody who's seeing what a cross burning means understands what the heck that message is, right? So it is expression, and when we have expression, we got to think about what the First Amendment says. But really, there was a big push in the 80s and the 90s to criminalize this. And what I want to make really clear to start off is, actually, let's look at the statute first, okay, and a brief resuscitation of the facts of the case. So the statute in RAV versus City of St. Paul, which is a Supreme Court case from 1992, says that it is a crime on a public or private property to display an object, symbol, including but not limited to a burning cross or a Nazi swastika, which one knows or has reasonable grounds to know arouses anger, alarm, resentment, and others on the basis of race, color, creed, religion, or gender. Now, the facts of the case, so that's the statute. The facts of the case: teens, a couple of white teens, went into, inside the fence of an African-American family and burned a cross. Now, before we get to anything else, what crimes could those teens have been charged with? Is there any argument that what they did was allowed, was legal? So if I go into my neighbor's yard and I burn a pile of leaves in their backyard, what can I be charged with?
Arson?
Arson, right? Arson, certainly. Trespass.
Destruction of private property, technically, I guess.
Yep, destruction of property. Absolutely. Right? So these are crimes that they could have been charged with. Okay? So, regardless of whether or not you agree with this case or disagree with the outcome of the cases, we'll see. This is not saying that what these teens did was legal. The statute is criminalizing the racial prejudicial nature of the cross burning, right? It's treating cross burning differently than burning of anything else. And the reason for that, pretty obvious, right? If I burn a pile of sticks in my neighbor's yard, that sends a much, much, much different message than across in the front yard of a black family. It just does. And so it's understandable, and I think relatively, good, that the City of St. Paul wanted to criminalize the specific harm that comes with this sort of racial attack, racial threat. And I guess the reason I didn't have you guys read this case is because it does get a little bit convoluted, because initially the City of St. Paul justified this as a fighting words regulation, saying, look, this is fighting words. And the court said, no, it's not, because it's far too broad for that. Essentially, they're saying that anytime a swastika or a cross burning is displayed, that it is likely to invoke an imminent breach of the peace, and there are situations in which that would not happen, right? If somebody burns a cross by themselves, or they do it you know, in the middle of the night when nobody sees it until the next morning, right? Like, obviously that is bad, that is harmful, it's going to cause a lot of distress, but it's not going to cause an immediate breach of the peace in the same way that we see in Chaplinsky, where you call somebody a bad word, they get offended and they hit you. There's that like snap moment decision. So it's not fighting words. And so that was a very, very poor argument, probably by the city of St. Paul. But I'm sorry. But even so, Scalia, even if it was fighting words, Justice Scalia, who wrote the decision, said that this statute is unconstitutional because it only applies to fighting words that are uttered with regards to specific topics and specific viewpoints. It is targeting specific types of speech. And when you're looking at fighting words, when you're looking at threats, when you're looking at trying to regulate speech, the one thing you absolutely can never do as a government is target specified viewpoints or specified topics that you are going to favor or disfavor, regardless of how much the population at large finds these opinions abhorrent. And understood, racism is horrible, and cross-burning goes way beyond, you know, more run-of-the-mill racism, right? And Scalia and the majority said, look, you can't go after only specific topics, specific viewpoints. This statute that City of St. Paul passed, let me give you an example. On its face, if I burn, or somebody, I really don't want to say me, but if somebody burns a rainbow flag in the yard of a family with two guys or two women as the, you know, the parents, that's going to be targeted, right? That's going to be targeted as homophobic. It's going to be targeted as a hate crime or hate speech or whatever you want to call it. But there's a really good argument that that's not going to fall within the statute, right? Because it doesn't prohibit homophobic speech, doesn't prohibit bigoted speech. And so it's only specifying certain types. And that's going to be where this statute fails. That if you are going to try and appeal to these exceptions from the First Amendment, that you're going to have to make it viewpoint and content neutral. And if you try and target racism for elimination, you try and target sexism for elimination, it's going to be darn near impossible, because that would be the government targeting a specific viewpoint. And we'll talk next class about how there's a subsequent case in 2003 called Virginia versus Black that I'm going to have you guys read. That might be a little bit different. Might have a different outcome. So I still plan on being in class on Monday. Again, I do apologize about going remote, but I didn't want to cancel class and just was not in a position where I could leave the home today. And for all I know, I'm getting sick too, and I don't want to make you guys sick. Again, no concern for COVID. So those of you who were in class, again, there's absolutely no cause for concern. I got that confirmed by the doctor today. Otherwise, I will see you guys on Monday and be on the lookout for readings. Thanks. Bye.